This is something I wanted to do for some time, and I look forward to the opportunity when the Charles Taylor case would draw closure and the opportunity would present itself, never sure it ever would, where all of the 4 chief prosecutors of the special tribunal at Sierra Leone would be in one place, one time, to talk about the specificity of the Charles Taylor case. As you know, we're here at the 6th Annual International Humanitarian Law Dialogue, and the title of it is the Special Court for Sierra Leone, a 10-year anniversary retrospective, with the question, is the justice we seek the justice they want? Now, that's going to be the overall theme that we'll be discussing throughout the next couple of days. Tonight, though, we will be focusing in on a case which just concluded, and that is the case against Charles Taylor, the leader or the head of the National Patriotic Front of Liberia from the late 1980s onward, President of the Republic of Liberia from August 2nd, 1997 until August 11th, 2003, when we'll talk about how his presidency ended. We have a very distinguished panel, and running from, I guess this would be your left, David Crane. David Crane was the initial chief prosecutor. Next to David is Sir Desmond De Silva. Next to Sir Desmond is Stephen Rapp, also Ambassador Stephen Rapp. And next to him is Brenda J. Hollis. Brenda is the current chief prosecutor of the Sierra Leone Tribunal, and we're just so thrilled you're here. I don't think you've been together much, have you? As I understand, maybe when the verdict was given, that perhaps you gathered at that moment. But in the meantime, just having you all 4 here at the Robert Jackson Center, and as one of the founders of the Jackson Center, I'm just thrilled as this is a wonderful, I'm looking at the 4 of you, a continuum of what the work done by United States Chief Prosecutor Robert H. Jackson, which finds its way and its legacy through the work the 4 of you did at Sierra Leone, and specifically dealing with the Charles Taylor case. Let me just get this into perspective. This is the statute of the Special Court for Sierra Leone. Having been established by an agreement between the United Nations and the government of Sierra Leone pursuant to Security Council Resolution 1315 of 14 August 2000, the Special Court for Sierra Leone shall function in accordance with the provisions of a statute which was created. The Special Court shall have the power to prosecute persons who bear the greatest responsibility for serious violations of international humanitarian law and Sierra Leonean law committed in the territory of Sierra Leone since November 30th, 1996. Within the articles is an article dealing with the prosecutor, Article 15. The prosecutor shall be responsible for the investigation and prosecution of persons who bear the greatest responsibility for serious violations of international humanitarian law and crimes under Sierra Leonean law committed in the territory of Sierra Leone since November 30th, 1996. It goes on to state, the prosecutor shall act independently as a separate organ of the special court. He or she shall not seek or receive instructions from any government or from any other source. David Crane was the first chief prosecutor of the Special Court for Sierra Leone. To put this into perspective, David, were you aware before you were being considered as a candidate of the existence of that court?
No, I was not. I just wasn't. I knew that there were issues in Sierra Leone, but at the time, before I was asked if I would be interested, which I didn't take seriously because I was an American and nobody was going to pick an American to be a chief prosecutor at the time. If you recall, we were unsigning a rather important document and the world was frankly angry at us, and I thought that my candidacy was a throwaway candidacy, and I really didn't take it seriously for quite some time.
At one point, you get a call, and what was the conversation like?
You got to be kidding me. Well, you know, it was interesting. It was 2 weeks before 9/11, And I had a very senior position in the Department of Defense. And yes, I was interested. I mean, who wouldn't be interested? But I had a lot going on. And after the call, Judy asked me who that was. And I said, and she laughed and said, "You're not going to get that." And I said, "I know." And we promptly went back to our spaghetti dinner. And 2 weeks later, the planes hit the buildings. And frankly, we were both seniors in the DOD. And so we were at war, and we just moved on. And I got a call, actually it was from Mike Newton. Mike, are you here? From the War Crimes Office. He was working, he was the deputy, and said, "Hey, send me your resume." And I said, "You're serious about that?" I knew Mike. Mike and I have known each other for well over a decade, and so I did, and the rest is history.
Well, talk a little bit more about the history. You get appointed this is United Nations appointment?
Yes, it was, and it was interesting because it was a first ever idea. It was a hybrid model. It wasn't an ad hoc. The appointment process went through pretty similar to other.
Can I stop you right there? This is for the students. Explain a little bit what you just mentioned, the term hybrid.
Well, certainly. It's a mixed court. It consists of both international jurists as well as, in this case, barristers, jurists, judges, what have you, from Sierra Leone. And the concept is a good one. The mandate was as well. But a hybrid model, it was the first time ever in history that the concept of a hybrid international war crimes tribunal was considered.
When they appointed Justice Jackson, President Truman did, they told him a lot about the evidence that was available, about the fact, in essence, a lot was in place, and that you would just have to basically be an administrator / prosecutor. What did they tell you was available as far as evidence?
I had no idea what evidence we had. I know that there was a working group that went out in January of 2002 and found some evidence, but there's no train loads full of documents directly implicating 23 individuals for war crimes and crimes against humanity and genocide. There was very little evidence, frankly, that we initially had. So we had to go out and find it ourselves.
At some point, you kiss Judy goodbye, and you get on a plane, and next thing you know, you're in Freetown. What was your welcome like?
Well, we arrived on this plane. It was the first time, then it was called SN Brussels, that had ever flown into Freetown. There were like 12 people on this 777. The stewardesses were thrilled. They flew we landed in Guinea, in Conakry. Then we flew from Freetown, which is only, 75 miles away. They never got above 1,000 feet. We napped of the earth straight to Freetown. It was a rather kind of strange. We landed. There was no one there. We went through and we stood around in a hangar waiting for this widowmaker called Paramount Airlines, which took us to the other side of the bay. And there standing was the entire Special Court for Sierra Leone. We quadrupled the size of it. There was Robin Vincent, the late registrar of the court, standing next to a vehicle that he somehow stole from the UN, and welcomed us to Freetown.
What was your sense? I mean, you really had to develop this out of whole cloth.
Indeed.
Did you get any guidance as to what the other tribunals at this point, Yugoslavia and Rwanda, were in place, as far as just templates for what you might use, David?
Of course, and I was doing a lot of listening and a lot of talking, and the nomination process took 6 months, and I was reaching out. In fact, I invited Brenda Hollis, who had been in town, to come by my office in the DOD, Department of Defense, and we chatted and got her perspective. But I immediately reached out to NGOs, Physician for Human Rights, Human Rights Watch, what have you, just to get a sense of what was going on there in Sierra Leone. Of course, I was in government, so I had an ability to find data on Sierra Leone. So I was gathering and doing and meeting with people. So when I was called by Hans Corell, actually, that I had been chosen to be chief prosecutor, I had already planned out the entire prosecution in 10 phases, of the phases of which we largely kept to, and presented that at the U.S. Institute of Peace in May of 2002, about a month after I had been chosen. And I think that's where I met Bill Shabas for the first time, who had just been picked to be a member of the Truth and Reconciliation Commission. And I told the assembled people from the UN and NGOs, here's how we're going to do it in a strategic sense. I mean, I wasn't telling them about my case. So when we left, we already were in phase 3 of a 10-phase program, our intent being to be somewhat fully operational in at least a office sense by November of 2002, and we were largely in that position. And then, of course, we executed Operation Justice, led by Alan White, who was also here, my Chief of Investigations, on 10 March of 2003.
And prior to that, you had to gather information, identify who were the individuals most responsible. What was the process like?
Well, of course, I was dialoguing and asking the community who they thought, but more importantly, we went and asked the people of Sierra Leone who they thought should bear the greatest responsibility. Now, I had a list, and I had about 20 that were within the ballpark, but we went out and asked. We asked colleagues and friends who they thought. Of course, I had data on all these individuals working in the U.S. government, so I had a sense of what was going on, but we went out very quickly, Binta Mansoureh and I, who is also here, registrar of the special court, and we went and asked the people of Sierra Leone. But by the time November rolled around, when Brenda and Desmond and I were actually starting to put pen to paper, we had a good sense of pretty much who bore the greatest responsibility, which is the first time that standard has ever been used. And we had some interesting professional dialogues as to, once we started, the closer we narrowed it, we started to have to throw some people back in the water, some of the fish, because we had some individuals who were bad people, but did they raise to the level of greatest responsibility?
At one point, you're having a staff meeting with individuals, many of them around here today, and you came up with the name of Charles Taylor. Now, he's a president. He's a sitting president. What was the conversation like?
Well, certainly I think that all of us that were at that table realized that Charles Taylor was in this mix somewhere. The evidence, as we began to develop this, what we call just euphemistically the West African Joint Criminal Enterprise, we sat down on a wetboard and drew out the criminal enterprise. Guns, diamonds, gold, timber, where it was going, who was bringing in the arms, and we began to see who the peripheral players were and who were those who bore the greatest responsibility. And interestingly enough, we kept tripping over Blaise Compaoré, and we tripped over Muammar Gaddafi. Now, we never seriously thought of indicting those two individuals, but they were clearly involved. But our decision at the end of the day was it all went back to Charles Taylor. Fortunately, the statute allowed us to indict a sitting head of state.
So on March 3rd, 2003, you sign and file the indictment against Charles Taylor while he was the sitting president of Liberia. What's the process? You sign a piece of paper. Where does it go? To the judge?
Well, again, Charles Taylor was just one of, I think it was 6 on that. And we had a ceremony on the 3rd of March of 2003. Brenda and her teams had been working long hours. I had spent long hours along with Desmond reviewing all of that. But on the 3rd of March, we had a ceremony in my office. We brought together the entire office of the prosecutor, which was about 30 people. Tom Perriello had brought in some champagne, I believe. It was warm, but so what? And what we did is we had our stack of our indictments. Brenda was the acting chief of prosecutions, and we started with indictment number 1, which was, I believe, Charles Genke MacArthur Taylor. She slid it across from me. I signed it. And then what we did is we had members of the team, our OTP, print out a copy of an indictment of the individuals that we were indicting, Fodisenko, Hinga Norman, all of the people that had destroyed this area, to pick out an indictment that they would like to be originally signed by both myself and Desmond, which we did as well. But we first went through the whole indictments. We signed each one of them. Taylor was first. I believe that Samuel Balkery was number 2, and then it went Fodi Sanko, Hanga Norman, all the way down, and we finished that off. And then we went and we had individual members of the team. We signed their indictments, and we took pictures standing next to the flag of Sierra Leone. And then we poured some champagne, and someone had a tape. I don't know who did this. If you recall this, it just occurred to me now. Someone played Ode to Joy. And it was a very moving moment, and I was looking around the room, and there were people who were weeping. You know, here we are, 7 months earlier, we had gotten off a plane. It was myself, Al White, and Mike Pan, and Robin Vincent. 7 months later, with a great team put together, not quite fully there, we took down a majority of the perpetrators of that horror story in 7 months.
On March 7th, 2003, just to have a timeline, the trial chamber, Special Court for Sierra Leone, confirms the indictment against Charles Taylor and orders it to remain under seal. Was there any question, any doubt that the court would confirm that?
Well, this is a great story, because what we did is, and again, Brenda and Desmond, please jump in, but we did some things that had never been done before. We did a thing called notice pleading. Our indictments were 20 pages. Or less, to include the signature page and the title page. Each of the charges were quite brief, and we weren't sure exactly how that would be perceived by the judges. And Brenda, the judges were meeting in London, and so once they were signed after the ceremony, Brenda took all of the original indictments with the packets that support that, probable cause essentially, and flew up to London to present those to the duty judge, Article 28 judge, for just a review. It's not a probable cause type review, but it's is there a crime in this individual? There's evidence to show this individual did it. And so, Brenda, you might want to just describe that moment in London.
Well, it was quite interesting, and of course we have with us tonight the judge who actually reviewed those indictments and approved them.
That's right.
Judge Bencoley Thompson. And they were in London having a plenary session where they were reviewing the rules of procedure and evidence and amending them as they felt was necessary. And so Judge Thompson was taking the indictments, reviewing them, coming asking questions, working on the plenary for the amendment of the rules. And then eventually all of the indictments that we took to him were approved by him. And I went back to report that to my boss in Sierra Leone. But first, Robin Vincent and I made a trip to The Hague to see if at least one of our indictees could be held in The Hague, because there was concern about the sensitivity of that prosecution. And the thought was it might be better to have him out of the country, at least until the time of the trial and perhaps for the trial itself. So it was a very busy time for the judge who had to review all of that
It was quite
in
the
the midst
packet.
of the amendment of the rules. And then eventually I made my way back to Sierra Leone to brief everybody, including my team, who had been up for a couple of nights putting everything together before I left. So
I
it was
remember
an eventful time.
remember getting that call. We were at Mamba Point. Al White and a couple of people know where Mamba Point is, and my phone rang, and it was Brenda from London. And, you know, we're all sitting on pins and needles, and we're having pizza and beer, which we usually did at that particular, I think it was a Friday night. And phone rings, and it's Brenda, and she said, he approved them. And I just leaned over and I said, they're approved. And of course, there were the usual suspects, Gilbert Morissette, and yelled out to my Canadian friends, I apologize. He goes, Tabernac! And it was a joyous occasion, because we weren't sure whether we had done this right. I mean, because this was a new kind of way of charging. But it was a special moment, because, again, at the end of the day, it wasn't about us. It was about the people of Sierra Leone.
So you have indictments in hand. Now you've got to decide, and as I understand it, part of that was the Charles Taylors would be under seal. The rest now are fair game. They're live. How did you decide you were going to serve those?
This is a 4-month-long effort that's culminating. Corollary to what Brenda and her team is doing, of corollary to what Desmond and his team is doing, preparing pretrial briefs, we're also secretly working a geopolitical national security team made up of the British High Commissioner, the American Ambassador, the Chief of Staff of the force of the UN peacekeeping force there, the IG of the Inspector General of the Sierra Leonean Police, and the British commander of the training unit there, Brigadier, who were quietly putting together the takedown. Of course, we didn't reveal anything that they couldn't know, but I said that as we worked along, we were planning this. And I remember going to London, meeting at the British Ministry of Defense in the Foreign Commonwealth Office, asking for, should this thing go sour, we were probably going to need military backup. And so we developed a plan where the 3rd Battalion of the Parachute Regiment was going to land in an ostensible training exercise a week before the takedown, which they did every year anyway, so there was no visibility. And so they quote, this year what we're going to do is we're going to take down the airfield. And so they went in and took down the airfield. Also, we had agreed that the West African Squadron of the Royal Navy was going to sortie and sail to Sierra Leone and be just over the horizon during just the beginning of Operation Justice, where we took everybody down in 1 hour across Sierra Leone. And we had 2 frigates and a destroyer of the British Royal Navy off the coast over the horizon. And then, at noon, when the takedown took place, the HMS Iron Duke sailed into Sierra Leone Harbor at general quarters and sailed up and down the beach with their flag flying and their guns up, just to let whoever thought this was not going to be a good thing know that the British Navy is there. And we also, again, you remember, we have the 3rd Battalion of the Parachute Regiment has already seized Lungi Field. So we were ready in place in case this went sour, that we were ready to evacuate, to do that. And also during this time frame, we had Pakistani Special Forces standing by to secure the 3 landing zones where we had helicopters that were contracted by the United States to take our indictees to a secret camp that we had put together on Bont Island under the ostensible of a legacy program of fixing a jail as our first efforts of showing our respect to the people of Sierra Leone. We, quote, fixed up a jail in Bont Island, and they thought it was just going to be something we were going to hand over to the police. And really what it was 9 jail cells of the individuals, to include the individual, Inga Norman, who was the Minister of Interior, who actually was in charge of the prison system.
So then somebody has to pull the trigger.
Well, and this gives great credit to Alan White, the Chief of Investigations, who is here. It was handed over to him. Brenda had done her job. We have approved indictments. The indictments are ready. They're in proper form. Arrest warrants had been executed by this duty judge. We were ready to do, and so it was handed over to Alan White and Gilbert Morissette, who had assembled a team, who had already put eyes on target. All of the individuals who had been indicted were already being followed, and it was Alan White then who executed it on the morning of the 10th of March. It started at noon, and at 12:55, he called me and said, we have all of them. Most of them are in helicopters. Jim Johnson, who was at the time one of the heads of our team, the CDF team, was detailed to represent the Office of the Prosecutor, where each defendant was given his packet, indictment, arrest warrant, advised of his rights, right to counsel, and that was served on them while they were in the helicopters flying off to the incarceration facility on Bont Island, 150 kilometers south of Freetown. They don't teach you this stuff in law school.
No. Needless to say, the newspapers in Freetown would have had a very large headline. What was the reaction in the populace?
Well, you know, it's interesting. When we were there, we'd also had planned that at 4 o'clock that afternoon, I was going to address the world's press, and Desmond and I went down to the UN headquarters. And the press secretary for the UN headquarters said that Mr. Crane is only going to read a statement. And so there is some, there is some press there, regional, international, as well as local. And so I just read this statement that today is a new dawn for Sierra Leone. That statement is online, you can read it. But I basically carefully read out all of the individuals who had been indicted and arrested. Of course, I left one out, Charles Taylor, because it was already sealed. And I stopped. And that's what the reaction was. I've never seen a group of press just look at me, blinking, trying to fathom that we had already taken down most of those who bore the greatest responsibility. And all of a sudden, the first guy broke for the door, and then it was, boom, the room emptied in 5 seconds to publish their stories. Now remember, this was only 2003, so we didn't have a thing called real sophisticated cell phones. They actually had to go use landlines and stuff like that, but they went out to file their stories. And so, as I was driving back to Seaview, word was getting out, and people were flowing into the streets in a positive way. Though we had a lot of people with guns at the ready just in case, and the HMS Iron Duke was still floating about, but the day ended quietly.
Did you guys have a lot of protection?
We did. We had to. We had a 30-foot wall around the Seaview, concertina wire. We had guards at the gate, close protection, a lot of guys with guns around. But yes, we had to be careful. We kind of stayed in the compound. Everybody on the team kind of stayed close because we weren't sure how this was going to react. But at this point in time, Charles Taylor does not know he's indicted.
Does Charles Taylor, in hindsight now, does he know that he's in harm's way?
No, not really. Not at this point. Our concern was he was going to start knocking off witnesses very quickly if he would have even had a hint of that. Something I'm going to be very proud of, and certainly my colleagues here can echo this. This was very sensitive information, and we had Sierra Leoneans and people from around the world drafting these indictments, investigating, and not a word leaked. If someone would have said one word, none of this would have worked because they would have fled into the bush. So I'm very, very proud of the operational security and the sense of duty of our office. And this happened for the rest of the years that I was there, and I know it was that way subsequent. The professionalism of not letting this get out saved lives and allowed this to happen in a just and appropriate way.
June 4th, 2003, Charles Taylor was attending peace talks with other African leaders in Ghana. You decide to unseal the indictment. Why then?
Well, again, this is not just a sudden, I got up one morning and said, I think I'll just flip the card. This was also an operation that we had put together, carefully considered. We weren't exactly sure when it was going to happen, but we began to play with Charles Taylor's mind a bit. And I got into a newspaper back and forth with him. Because we knew we had Johnny Paul Koroma somewhere in Liberia at the time. We also knew that Samuel Bakri was working for him in the Ivory Coast, leading his force that was causing disruption in that country. And so as part of this plan of starting to ramp up our move towards taking Charles Taylor down, we put in the press that Charles Taylor is harboring indicted war criminals and demanded that he hand them over. Johnny Paul Koroma, Sam Bakri. If he had said nothing, it would have probably died, but he bit, and he began to deny that he even knew he had them. Of course, we knew exactly where they were. Alan White had developed an information asset system. Basically, he had assets looking at them. So we knew exactly where they were. So what we did is we just did just that. We told to the press exactly where they were. So what this did is this playing with Charles Taylor's mind that we had penetrated his inner circle. We knew what he was doing. We knew where these guys were. Well, he did come back and admit that they were there, and then I demanded that he hand them over. This is in May of 2003, and demanded to be handed over for a just trial. And all of a sudden, out of the clear blue sky, we get this note that Samuel Bakri had died resisting arrest. And I demanded that the body be sent to us. And on my birthday, 29 May 2003, Charles Taylor sent me Samuel Bakri's body in a cardboard box on the back of a UN helicopter. And I remember standing there in the rain, watching them slide that cardboard box off the back of that helicopter. And it was just very, very chilling. Of course, we found out subsequently in an autopsy that he had been shot by a firing squad. 2 hits here at an angle of 45 degrees. They kneeled against the wall because there were chips of the wall on his back, and 1 guy pulled. So he had 4 across his heart and 1 got here. So he was lined up in front of a wall and shot. We subsequently learned that Charles Taylor had also killed his family and his children and his mother-in-law as well. But that's how he reacted. And so at the time, we didn't know exactly what was going on, but there was a lot of pressure on him he was in the middle of a battle with rebel forces against him. And the Accra Peace Accords began to come together. And all of the leaders of West Africa, as well as other African leaders, were called together to to try to solve the Liberian mess. And at that point, and again, this is never done in a vacuum. This is hours worth of discussion and back and forth with our senior team, just saying what are the consequences. So the plan was on the 3rd of June, I went and told the American ambassador, the British High Commissioner, the President of Sierra Leone, and the SRSG that within 24 hours a significant event would take place that potentially would impact on their national security. During this time frame, Robin Vincent had put together the arrest warrant, the indictment, and the next morning at 8 o'clock, he served that on the Ghanaian High Commissioner. This is where Charles Taylor was. The Ghanaian High Commissioner, he also faxed and emailed copies of that information to Ghana, the Foreign Ministry. As soon as that was confirmed, then we had letters from me to the President of Sierra Leone, the American Ambassador, the British High Commissioner, the SRSG, that 11 o'clock today I was going to unseal the indictment against Charles Taylor. And we did. At 11 o'clock we held a press conference, and it was amazing. Sometimes these things take on some type of movie drama, but he was walking up the steps in Accra, President of Sierra Leone. I unsealed the indictment at the moment that he entered the hallway. He was told that, and I'm told this afterwards, that he had just been indicted for war crimes and crimes against humanity. He was moved off to another room, and he conferred with several heads of state, Thabo Mbeki from South Africa, John Kufuor from Ghana, and I believe Obasanjo from Nigeria. And they hustled him off into a car and back to Liberia, and got him back to Liberia. We never thought that they were actually going to hand him over. We would have taken him. In fact, we were ready to take him. But in reality, they chose not to. And then thus began the fateful summer of 2003, where the back and forth, where finally U.S. Marines were brought in to stabilize, and then a peacekeeping force was brought in. And in August of 2003, he stepped down as president of Liberia and was sent off into some type of exile/house arrest. I never really could put my hands on it, in Calabar, Nigeria, where he resided for the next several years.
Then enter Sir Desmond de Silva.
Indeed.
So you have been working with David, the Deputy Chief Prosecutor. By the way, you may want to bring your mic up just a little bit, Sir Desmond.
Yes. I mean, once the indictments had been opened, David asked me to be in charge of any appeals that arose, because curiously there were a number of jurisdictional issues that arose, and so as to enable the trials to proceed in a speedy fashion, these jurisdictional matters were dealt with prior to any trials beginning. And I handled all those through 2003, and so on and so forth. And then, knowing that we had to get Taylor, David said to me, Desmond, I'm going to ask you to try and mobilize opinion in order to get one country after another to call for the surrender of Charles Taylor. So I said to David, I'm going off to go to the European Parliament, where I had a number of friends, and I mobilized them, and a resolution was passed, a unanimous resolution. And I say this because the European Parliament has never agreed about anything before or since. But on the issue of Charles Taylor, I mobilized them, and they passed a unanimous resolution that Charles Taylor should be surrendered to the Special Court, and indeed further, that resolution should be sent to Congress and also to the Secretary-General of the UN. So that was fairly successful, because I remember calling David from Brussels, and he said, how many votes? And I said, unanimous. And he seemed to be reasonably pleased with
I was somewhat pleased.
His deputy at that stage. Well, then I also had a similar resolution passed in the House of Commons in London, and so on and so forth. The whole object was to ramp up the pressure so that the world knew that the opinion was that this man had to be brought to justice. But of course, then we had the continent of Africa to deal with, and again, we met with some success there. But then David, having very successfully, as I say, indicted Taylor, David left Sierra Leone, and his mantle fell upon my shoulders, and it remained for me to carry on the fight. So I had to sit and think how I was going to get this fellow. So he was there on the Calabar coast of Nigeria, where he had repaired to with a great deal of money and a large number of ladies of the night from Liberia. How was I going to prize him out of Liberia and prize him out of Nigeria and prize him away from these ladies? Well, that was a great difficulty. So at that time, of course, we moved to, I think, 2005, and President Obasanjo of Nigeria had become a great friend of Charles Taylor. And Charles Taylor used to spend every weekend at Obasanjo's country lodge. Obasanjo would be at one end of the table and Charles Taylor at the other. And so I realized that no way was I going to get this man, because of the friendship that had developed between these two characters. So something fairly original had got to be thought of. Some may remember that this was a time when there was a great deal of talk about the expansion of the Security Council. As you all know, the Security Council consists of 15 members, five of whom are permanent. And Nigeria, on account of her peacekeeping role in West Africa and other parts of Africa, hoped to attain a place as a permanent member of the Security Council. And I knew that Obasanjo was after this. It would after this for Nigeria. And this is something he very much wanted. My opposite number in The Hague, Carlo Del Ponte, had adopted a policy so far as Serbia was concerned, and when Serbia was applying to join the European Union, Carlo Del Ponte had in effect taken up the position that she was going to oppose it because Serbia had failed to surrender Mladic and Karadzic, those war criminals which we know about. So I adopted a similar tactic, and I said to the High Commissioner for Nigeria in Sierra Leone, I said, will you please pass it on to your president that I will object in the same way as Carlo Del Ponte has objected. I would object to any consideration being given to Nigeria being looked on as a possible contender to join the Security Council, because your president is giving house room to an indicted war criminal. Well, I did this about 2 or 3 days before President Obasanjo of Nigeria was to come to Washington, and he was due to come and see President Bush, and I chose my moment carefully. And I was also in touch with Washington, and there were certain doubts being expressed by the State Department at that stage as to whether or not President Bush was going to meet him. So President Obasanjo realized that he was in some difficulties. We knew that, at least I knew, that there were about 100 people looking after Charles Taylor where he was in Liberia. And then I got an intelligence report to indicate that there were only 2. So I realized what the game plan was. The game plan was to lift security on him so that he could make a run for it. And I didn't quite know what was the end result of that run was. But I now know, of course. He made a run for it, and then President Obasanjo had him arrested on the border with the Cameroons on the basis that he had broken his promise to stay where he was. And on that basis, he was surrendered. And I remember starting the day, on a particular day, I never knew what was going to happen. By 9 o'clock that morning, I realized that Charles Taylor had been picked up on the border, and as the hours progressed, I realized that he was going to be flown out of Nigeria. Ellen Johnson Sirleaf, who was the president of Liberia, was absolutely terrified, because she was terrified that Charles Taylor's supporters, were his plane to put down in Liberia, might do something. And so we had quite a substantial UN military presence at the airport when the plane taking Taylor arrived. And then there was a complication. It was about 6 o'clock in the evening, and I was on the telephone to whoever it was in Liberia. I said, oh, now he's going to be handed over to people from the special court. He's got to have a full medical. I said, what medical? They said, well, he's got to have his heart checked. And I said, I'll check his heart here when he comes, don't worry. So I got on to the American ambassador in Freetown and said, look, I said, all you Americans are hypochondriacs. You've all got, I'm sure you've got a heart machine in the embassy. The American ambassador said, yes. I said, can I borrow it? So I called Liberia and said, no, just send him through. I've got the heart equipment here. And it was just as well, because the weather was closing and all sorts of things could have gone wrong. And certainly by 7 o'clock that evening, I can recall it now, standing there in the compound of the special court, watching this helicopter come in, guarded by helicopter gunships on either side. And then eventually Charles Taylor got out of this helicopter. He was manacled, looking rather disheveled, and his rights were read to him and so on and so forth. And he was put into a cell now, as you know, in all sensible places. This was true of Sierra Leone, that once a person's arrested, he's supposed to be brought before a court at the earliest opportunity. I got a message from Charles Taylor saying, well, I'm very disheveled. Would you mind waiting 3 days whilst I have some clothes sent for me from London and Paris? And all those who watched Charles Taylor, seen him on television, will realize how immaculately dressed he always was. And I thought to myself, oh, well, never mind the rules that say that I got to get him before a court at the earliest opportunity. If this man's going to spend the rest of his life in prison, and he wants to be well dressed before on the first day, why not? And so these are sort of fine judgments you've got to make as a prosecutor. And that was one of my finer judgments. And, well, he appeared in court, and then, of course, the real problem was that Ellen Johnson Sirleaf in Liberia was absolutely petrified that the trial would take place in Liberia, in Freetown. And so she was on the telephone to me all the time to get him out. And of course, where was I to get him? Because the seat of the court was at Freetown. And so I had to fly to New York. And I saw the American permanent representative as well as the British permanent representative and said, now, look here, you people are going to have to pass a resolution to get him tried in The Hague because I'm stuck with this man in Freetown and I've got to get him out. And certainly the British and the Americans agreed and a resolution was passed. Then I thought that was the end of my problems. Then the Dutch said, no, we're not going to try him unless some country agrees to take him once he's been convicted, if he's convicted. So I had to start all over again. So then I eventually went from country to country saying, will you please take this man if he's convicted? And they said, no. So then I went to the British government and said, now look, you were kind enough to pass a resolution to have his trial in The Hague. Now you've got to take the responsibility of putting him behind bars in Britain if he is convicted. So finally Britain agreed. Then and then only did the Dutch agree to the trial in The Hague. So it was a lot of convoluted stuff, doing and froing, a bit of blackmail of Sanjay, and so on and so forth. But there it was, and it's all in a day's work for a decent prosecutor, and there it is.
There it is.
So you did all the hard work. You got him to The Hague.
No, I didn't know the hard. David, of course, indicted him. I got him. You, of course, opened the case against him, and Brenda put him behind bars. So we've all played our bit.
All right, so we have him now, this high diplomacy at The Hague. And by the way, the night that, as I understand, your good friend Jim Johnson was explaining how you spent the afternoon while you were waiting for Charles Taylor.
Well, you've got to pass the time somehow. I recall a few corks popped and so on. And there was some liquid refreshment taken.
And I think
Of a purely innocent kind.
that may not make the final cut, but anyways, I had to ask. Then, now, Steve, it's your opportunity. How did you, by the way, were you in the court at that point?
No, absolutely not. I was over in the other side of Africa, in Arusha, watching all of this and meeting periodically. I came over to the court as part of our meeting of international prosecutors in June of 2005 with Hassan Jallow, who was my boss, the prosecutor of the ICTR, and was quite interested. And I remember how excited I was, almost as excited as those people were in Freetown when Charles Taylor was flown in on that late night in March of 2006. It happened a few weeks after the death of Milosevic, which was a tragedy in The Hague, and this was really an opportunity now for international justice to try a chief of state in a process that was transparent and fair and in a way that would do the world proud, and wanted very much to see that done. I hadn't seen myself in that role, but I think it was about July of that year, Desmond decided to resign, and the position became open. I was encouraged to put my name in, did not think I had a realistic chance, was interviewed in November, but was very busy as chief of prosecutions, trying and supervising cases in Arusha for those responsible for the Rwanda genocide. And I remember I was even leading a witness in trial, and very exhausting experience, was sound asleep at 2 a.m. in the morning on, I think it was about the 6th of December, when I got a call from New York from the Assistant Secretary General, the Deputy Legal Counsel, the American Larry Johnson. And I couldn't understand what he was talking about for a while until I suddenly realized that I was being offered this position as Chief Prosecutor. And of course, they wanted me there yesterday. The UN had commissioned a report from Judge Cassesi, the first president of the ICTY, that had suggested that, that there were a lot of challenges now at the Special Court for Sierra Leone in getting this case tried. And the first thing was they needed to have a prosecutor, they needed to have a trial team. And so I flew, got some time off from JALO, and was in Freetown within a week, meeting the team before the Christmas holidays, and decided I would arrive in January. But it was challenging. Taylor had been flown to The Hague at the end of June. One of the first things I did was a pretrial conference where the judge was still talking about an April 2007 trial date. Brenda had been involved as initially, but then as a consultant that had drafted a very good revised indictment that had cut the counts down from 17 to 11, that I think it was confirmed just a few days before Taylor was arrested, but wasn't working with us, and as I understood, wasn't interested in coming back. It didn't look like it was going to happen, and we had some very, very good juniors that were working on the case. But this was going to be a situation where I was going to have to be in Freetown most of the time, where we were still finishing our trials there, and where the court was headquartering, and where this is a very important part, and we're going to have to try this case in The Hague in just a few months. And so the first thing became, the challenge of putting together a trial team, and the crucial thing was to convince Brenda to take on that task. And within 3 days of arriving in Freetown in January, I was off to New York to meet Brenda to persuade her to agree to take on the leadership in the trial chamber of that case. And then we began the work of working to get this case in shape for trial. I'd led trials myself in Arusha, the media trial, which I took over in the 7th month of a 34-month trial. And we always know that you can read in the papers and read everywhere that this is the case, this person's responsible, this is what happened. But proving it in court is quite another challenge. And unlike Robert Jackson, who spoke in his opening address about these, we can convict these Nazi leaders on their own records. We didn't have many records. We had some newspaper clippings, a few other documents. But this was going to be a case that was going to have to depend on testimony. And it was going to have to depend on a lot of insider witnesses, some of whom had been used in the other trials, but many of whom were in Liberia, many of whom were in situations where they were at risk. And so the challenge was really to put together the evidence that we needed to tie Charles Taylor, who, as we've always admitted, at least in our relevant period, had not set foot in Sierra Leone for these horrendous crimes that were committed. And so, and this happened at the same time that we had the challenge of the court, which had then gone on for 3 years and had done these other cases, and the international community had said, well, do this thing in 3 years and be done. We had to raise the resources, raise the funds. This is a court that depended on voluntary contributions. Go to capitals and convince them that this was the most important trial in the world, and they needed to, not to be freeloaders, but to put their own tax dollars, own voluntary tax dollars, to work in the trial. But fortunately, we had a couple months delay, though it was a massive amount of work that Brenda and her team had to put together, I think, to meet the deadline for the pretrial brief that was due in early April to lay out this case. But the judges were quite adamant that we were going to begin the case on the 4th of June. And so on the 4th of June in 2007, we opened the trial against, and Brenda wasn't yet available to join us, and so it was myself and Mohammed Bangura that then were prepared to lay out the case before the judges. And those of you who watched it, or because it didn't get played here as much unless you got up in the morning at 4 in the morning, but we started it, and of course there was the famous scene where Taylor himself didn't turn up. His defense attorney was there and refused to participate, and the judges said, "You'll sit down and listen." And they turned to me, and I was beginning my address when the defense attorney started walking out of the courtroom. Went to the back door of the courtroom. I don't know if people saw this because it was playing live on CNN and BBC, but he went to the back door, and it was actually the door that Charles Taylor would have been, the room where he would have been detained, and so the door was locked. And he's trying very hard to walk out of the courtroom through a locked door with all his books falling around his arms until the judges finally interrupt me and say, "Mr. Khan, what are you doing?" And I'm just trying to walk out, judges. And eventually, as you may know, though they were quite disturbed about that, they basically said, "If you want to go and be contemptuous of the court, you can, but your duty counsel will remain." And so we were able to proceed and conclude our address that day. But it was clear that we also then had this challenge of making sure that Taylor had an attorney that would represent him, and the court spent a couple months finding a new team, and then there was a delay where we weren't able to begin the evidence until January of 2008.
I just got to ask personally, when you're on a roll, you're doing the opening statement, you're ready to rock and roll, and there's all these distractions. I mean, that must throw you off.
No, you can't be thrown off. I mean, there are so many things in this world that would throw you off. I mean, flying in. I mean, that very morning. I mean, it was a very tough morning for many of us because that morning we got up and found out that the Paramount helicopter that David was flying in on had crashed the previous night, killing everybody aboard except for one person, the helicopter that we'd flown on just a few days beforehand. Because if you're in Freetown, the airport is across a 20-mile estuary, and you have to fly a helicopter or take a boat or a ferry or swim. One way or another, you've got to get across, and it was there was a lot of things that were challenging, and I was actually, in the beginning of my address, honoring the people who'd given their lives the previous day, even before I got to the facts of the case. But before I got to those facts, we had the defense walking out. But there's a lot in this process that you just have to work. You constantly have to work through, and I mean, just day after day. I know it from all the cases I did in Arusha. That if you go to bed at night not thinking about 4 or 5, 6 things that could go wrong the next day, you're not being prepared, because there are just so many ways that you can have difficulties. You're bringing in witnesses from thousands of miles away. You've got just a whole variety of tough issues that have to be faced if you're going to be able to put on these kind of cases on trial.
You had quite a lag, though, between when you did the opening in June and the actual trial starts January of the next year.
Well, in terms of actually bringing on the evidence, yes.
Right.
Which, I mean, to be frank, we were able to benefit from that time to put together and organize our case. And we had, and understand we're using that time very well, and of course trying to make sure that we can continue to get the resources that the court needs. But it's a situation of having to make sure that we can put on a case, that we can try this case, provide an opportunity for the defense to challenge our evidence in every reasonable way possible, and complete it and go through an appeals process and have the resources to do it. And so we were constantly in this kind of tension about would we run out of fuel before we got to the end of the task. So we were constantly weighing the issue of how important this evidence was, how critical it was, ways that we could potentially shorten and limit our cases. And everyone complains about these international cases taking too long. We tried. We had, I think, 92 witnesses or so on our list. Eventually, we wanted to bring about 40 of them only on paper. They were crime-based witnesses, but we needed to prove. We had 11 different crimes. I mean, child soldiers and pillage and sexual slavery and rape and murder and mutilation, both as war crimes and as crimes against humanity. And the overarching crime of terror against the civilian population is a war crime. We had to prove that that occurred. And so we had to put on a certain number of witnesses. We limited the crime scenes the districts to only about a half of where the crimes had occurred, but we still had to do that. We tried to do it in a very expeditious way, and one of the ways the rules allowed us was to bring witnesses in writing, their written statements, if it didn't go to the act and conduct of the accused. Defense wanted to hear all those witnesses. Mm-hmm. They objected, I think, except in one case. So eventually we brought more than 90 witnesses to the Hague. Almost all of them had to be flown from Monrovia or Freetown and flown to Brussels and transported either by air or ground to our safe house. Every one of them appeared, testified, returned safely. It was an immense exercise, and many of these people had rarely traveled, more than 100 kilometers in their whole life. We put it on in, I think, a total of about 13 calendar months, about 44 weeks of trial, and then we had to face the defense case. But it was certainly one of the most challenging things that any of us have been involved in.
Your first witness was Ian Smiley, and I'm sure, why did you pick him, sort of an expert on diamonds? Was that just to get the press a little bit of attention? This is the blood diamonds? Was there that thinking?
Well, one always wanted to have to lay out the picture of what was happening there, and clearly the motivation for Charles Taylor, which was only reinforced as he was facing the necessity of fighting the various wars that he'd gotten himself into, was to be able to take advantage of the diamonds of Sierra Leone. It was Ian that talked about how those diamonds are the most valuable in terms of the run of the carat in the world, and they can be dug with back-breaking labor, but close to the surface in streams, and they provide a kind of wealth a kind of value that you can use to trade for guns and not just for guns. Also, in the classic case of one of the memos, Charles Taylor was delivered about 1,600 diamonds, and he allowed about 200 of them, I remember, to be used for arming the rebels, but the other 1,400 he kept for safekeeping, etc. So they were valuable for the war, but they were also immensely valuable for his other ends.
Well, it was nice of him for that safekeeping, because clearly one of the 92 witnesses you call was Naomi Campbell. And I just wondered if you offered your safe house as her safe house.
Well, this was, and understand that I was in the case, and Brenda, back and forth between Freetown and The Hague, had led several witnesses, including Taylor's own successor, Moses Blah, who was his vice president and earlier as inspector general, and we convinced him to testify against his former boss and as a witness. But we concluded the prosecution case at the end of February of 2009, and after the defense's motions to knock the prosecution case down were denied by the court, the defense case began in July, and shortly thereafter I was appointed to my position in the Obama administration, and Brenda, not long thereafter, became the prosecutor of the court. And it was during the course of the defense case that the prosecution moved to reopen, to add the testimony about diamonds that had been offered by Charles Taylor and delivered in South Africa in 1997.
So we're going to let Brenda talk about this.
She can, if she'd like.
Yeah, let's talk about Naomi Campbell, because I must tell you, our new president and CEO of the Robert Jackson Center was so thrilled to be here to talk about Naomi Campbell in great detail. So was it designed principally to draw attention back again to the trial?
Well, that's what the defense would have you believe. But actually, we called Naomi Campbell because one of the members of my team had gone on a vacation to visit a friend in another country in Europe. And when he came back, he told me about meeting someone who was telling some tales about Charles Taylor. And one of the tales was that Charles Taylor at one point went to South Africa and was at a dinner there and met this woman, Naomi Campbell, and actually gave her diamonds. And of course, we didn't know anything about that. But the time period when this happened was very important for us, because our evidence was that after a coup in Sierra Leone in May of 1997, and after Charles Taylor became the president of Sierra Leone, the coupists actually sent a delegation to Liberia to speak with Charles Taylor to get his support for the junta, because there was a prohibition on sending arms and ammunition and other support to this coupists government. They were unable to meet with him, but they met with his representatives. And when this delegation made its way back to Freetown, one of Charles Taylor's representatives was there and said Charles Taylor would help them get arms and ammunition, but he needed 90 carats in diamonds and $90,000 in order to do this. And the 90 carats in diamonds and the $90,000 were given to this representative and taken back to Charles Taylor. And it was not long after that that Charles Taylor went on this multi-nation trip, and the first stop was South Africa. So this story about him giving raw diamonds, rough diamonds to Naomi Campbell fit into the same time period where our evidence said he had been given these diamonds in order to get arms and ammunition. So it reinforced our evidence. So we began to pursue this and got in touch with Naomi Campbell's agents. We never were allowed to speak with her. But we also found out Mia Farrow had been at this party, as had the then agent for Naomi Campbell. We got in touch with them and they remembered it very well. So we thought this was important to corroborate this part of our evidence, because it showed Mr. Taylor was getting diamonds and that he was giving arms and ammunition to the rebels in Sierra Leone. So that's why we reopened the case. If he had given them to the cleaning lady, we would have called the cleaning lady, but he gave them to Naomi Campbell after they had apparently quite an enchanting evening together. So that's why we called Naomi Campbell.
It's consistent with what Sir Desmond was telling us about his habits then. Just out of curiosity, because I'm sure my wife's going to ask if I don't, what kind of witness was she?
She wasn't a very cooperative witness. In fact, our conclusion was that she lied. And there were many television reporters there. There were many of the satellite dishes outside. And close to where we are now, there is a Total gas station, and it has a little area where you can get sandwiches and Coca-Colas. And so I would sometimes stop in there and get Cokes or sandwiches, and so I got to know the lady that worked in there quite often. So after Naomi Campbell had testified, I went in the following Monday morning and I said, "Did you see all that activity at the court last week?" And she said, "Yes. I even saw some of that lady's testimony on television." And I said, "Really? What did you think?" She said, "I think she lied." And this woman knew nothing about the case. So she was not truthful.
So you really are now not only the chief prosecutor, but it's having been that constant theme throughout the prosecution. How do you think it went after you closed the prosecution? Your case closed and the defense came on. Did you have a feeling that where you were at the case, that you'd put in what you needed to put in? I mean, you feeling comfortable?
We felt that we had put in very, very solid evidence. That was one of the reasons that we closed our case when we did. We thought we had proven the elements. Of course, attorneys propose, judges dispose, so ultimately it was for the judges to decide. But we were very comfortable with our case.
Charles Taylor takes the stand on July 13th, 2009, and in his defense. What kind of witness was he?
He was quite eloquent when he spoke. His defense counsel was able to lead him quite a bit, so very often it was the defense counsel giving the story, and occasionally Charles Taylor saying yes, yes, no. But he is a very charismatic man. He's a very eloquent man. He's a very intelligent man. And all of that came across as he testified. And of course, he had the entire time before we began our trial, the entire time during our trial, and then many months after we concluded our evidence to prepare his story, to be able to explain our evidence, to accept it where he had to with minimal harm to himself. And he was very good at that.
The time frame was significant, but in November, you actually start the cross-examination. Did you feel like he was being truthful with you?
Not really. He was very clever, as I said. You could tell that he was a very good politician because you would ask him a question and he would give you a message response. So we didn't feel that he was truthful. But he had changed his story a bit. It was a very, very long direct examination, many months long, which gave him the opportunity to confuse his evidence and to say things that later would come back to haunt him. And we were able to use that in the cross-examination. And he would, on some occasions, even deny he had said it. And then when we would read to him from the transcript, he would still not be sure he had really said that, or we misunderstood him. So he was not a good witness for himself on cross-examination.
For his case, though, maybe that's an inappropriate question. At some point, the trial ends, and you have a chance to do the closing statement. As you prepared for that, were there areas within that closing statement where you knew you had to accent probably a little bit more than others, based on not only the evidence or perhaps the lack of the evidence, just as from a focus perspective?
Well, we felt that we had evidence to prove all of the charges against him as well as all the modes of liability that we had charged. So it was a matter of focusing on the areas that we thought perhaps the judges would give the most attention to as they were sorting through the evidence. And that's really how we focused our arguments. And really the Charles Taylor trial ended as it began, because as Stephen told you, Charles Taylor did not show up for the prosecution opening statement, and the defense counsel tried eventually successfully to leave the courtroom. And they also boycotted our closing oral arguments. So we were speaking to the judges, and there was nobody on the other side of the room.
Finally, they were convinced, though, to present their closing arguments. How did they do that? How did the court get the attention of defense counsel Griffith?
Well, they filed, we as the prosecution felt that when we received an order from the judge, it was an order. The defense seemed to at times think when they received an order from the judge, it was a suggestion. And the order from the judge is to file your closing submissions on a certain date, they took as a suggestion. And then the majority of the trial chamber said, you have missed the deadline, you may not file closing submissions. The defense appealed that, and the appeals chamber said, well, the defense counsel may have told you that, but you did not get an effective waiver from Charles Taylor that he really understood the consequence of that. So we're going to allow them to file written submissions and to make oral argument. And so eventually they did that in March, just before the hearing was closed.
And it was closed on March 11th, 2011, after 3.5 years. Now you're waiting for over a year. What kind of signals are you getting from the court as to how the deliberations are going, time-wise? I mean, this just got to be excruciatingly long period of time. Or did they tell you right up front this was going to take a year?
Well, they had various estimates as to how long it would take. We were getting no signals at all from the trial chamber, nor should we have been getting any signals. So it was a very tense time for us, because we were thinking, well, you know, we have a very strong case, and then time went by, well, maybe they don't think it's that strong a case. Why is it taking this much time? We didn't know, but eventually, in April of this year, they did come forward with the verdict.
So did they tell you that they're going to deliver the verdict on April 20th, 2012, or April 26th, 2012? Do you call your buddies here and say, come join us?
Well, we certainly put the word out, because, you know, you and I spoke about this earlier, but when you are preparing a case and then indicting and then prosecuting a case, it's a team effort. And the Taylor prosecution benefited from the hard work that had been done and the foundation laid by both David and by Sir Desmond. And then also we benefited really, Mr. Taylor being a fugitive from justice for 3 years, allowed the other cases to move forward, and we were able to benefit from those cases in refining our case against Charles Taylor. So, of course, I wanted them to know and to be there to share in whatever the outcome would be, because we had absolutely no inkling as to what the outcome would be.
How do you prepare your staff for the good or the bad?
Well, we talked about that, and I told them that no matter what happened, they had to remain very solemn, and that under no circumstance could they throw up in the courtroom.
So you're in there and you're listening and you are not given any clue, and in fact there's some negativity coming out as the judges are reading. How's your blood pressure?
Well, fortunately, I normally have low blood pressure, so when it goes up, it's not too bad. But it was very tense in the courtroom, very tense.
Were you folks there at the time?
We sure were.
Yes, we were.
Where were you? I mean, where were you located? You're in the courtroom,
Well,
or?
I was in with Steve and Fatou. We were in the audience watching.
Okay. Desmond, you were looking for your favorite area?
Well, Brenda, no, I wasn't looking for a bottle, no. Brenda very kindly invited me to sit in counsel's row.
Okay.
And so I was sitting at the back of counsel's row, so I was able to watch this historic judgment being delivered against this man whom I once called Africa's Hitler. It's a remark he didn't care for and complained bitterly, but there it is.
Again, respond, if you will, as you're hearing the judgment roll out, and again, we listened to it. I mean, everybody knew, and no matter what the hour was, and it wasn't all quite clear because you didn't prove, and then it was an interesting rollout. What was your sense of this?
I mean, there was a moment when I heard substantial. There was judges hint at these things, and you suddenly realized that they were saying substantial assistance was provided, and realized that would then open the door for them to basically say there was an aiding and abetting responsibility, and at that point, there was that feeling that this had been a success. I must say that later on, as the judges began to pull together and talk about the role of Charles Taylor in planning the attack on Kono and the campaign that led up to certainly the worst atrocities committed in a capital city, in memory, in Freetown in January of '99, realized that this was really an historic judgment that I knew from knowing the people in Freetown that had experienced that horror, from spending time with the amputees and the other people and those that had lost family members and those that had been raped and devastated, that the fact that the team had been successful in carrying forth the conviction of Charles Taylor's role in that horror was enormous and historic.
David, a question I meant to ask, but it must have run through your mind. 2003, when you unsealed the indictment, and the day before was the first time the United States government and other governments knew you were doing, and you were working completely independent as the statute provided. What kind of blowback did you get?
I'll never work in this town again, so to speak. Yeah, there was. I remember sitting with Colin Powell, saying goodbye to him. He would resign due to issues in Iraq, and I went by to say goodbye and just chat with him. And he was really my political cover in the Bush administration, which was furious with me personally. But I told him, I said, you know where this is going. They had full knowledge of the fact that Charles Taylor had that this was going in that direction, and so they should not have been shocked But they weren't happy. You have to understand in those days, the power of an independent prosecutor could take down a head of state. That wasn't something that had been done often and in the way that we had done it. And the U.S. was quite upset with us related to just that act of happening in that summer where there was a lot of back and forth where Charles Taylor clung to power even though he really didn't have any more power. It had allowed the LURD and the Force Model to attack. They were more invigorated. And so they really launched an attack on Monrovia to take it over, and which they tried to do, and the U.S. had to intervene. First time U.S. Marines had landed in Africa since Somalia in 1990, 1991. So it was a pretty tense time. As Sharif Bassioni mentioned, the world, it's funny, you do the job you're asked to do, and it's the only time in my life that I had people angry at me for doing it. And really, there was a lot of anger related to the takedown of Charles Taylor.
So,
And this is an important part of the lesson of the court. And I mean, many have seen this court as different and less independent than perhaps others, but each of the prosecutors has had to exercise that independence and make decisions and push this thing forward. I know, the decision to go after Sam Hangen-Norman and the CDF wasn't popular. I mean, the British ambassador, the High Commissioner, ended up testifying as a defense witness, and Desmond cross-examined him during the during the Sam Hangen-Norman case. Wow. But you have to make these independent decisions, and governments. I mean, I think the American government, was quite happy that Charles Taylor was charged, but there's always, this isn't the right time. Because it's frankly never the right time. You need to put your case together and make the decision that needs to be made. Of course, in the end of the day, you're also going to have to go back to governments and ask for their cooperation. It's a world of states, but it's in exercising independence in a professional way that these courts earn the respect, and the verdicts and the judgments that they render can have the respect of all the world.
Indeed, and stop and think about this. The world howled for about 2 months. Charles Taylor finally is sent off to Calabar, and a period of transition comes in. The United Nations comes in. Things settle down in Liberia. Things are settling down in Sierra Leone. A new government is formed in Liberia. The people of Liberia elect for the first time in African history a female head of state. And for some modicum of chance, we have a country that has the ability to move forward and rejoin the family of nations. That's in my mind, that's a great endorsement of our indictment, because the indictment is what took Charles Taylor out of the equation. And I think that over time, it is shown that in order to have true peace, you have to have true justice.
And you can look at it today. I mean, this is a court with limited jurisdiction. We only had the ability to go after those with the greatest responsibility. It was only 13 indictments, 12 of citizens of Sierra Leone, one of Liberia. But the impact of these judgments, of sending the signal that no man is above the law, that you don't gain power through violence, you don't gain power by terror, has created, I think, has contributed certainly to a situation where it's been possible for power to change hands in these two countries without lethal violence.
Indeed.
Sir Desmond, what's the legacy?
Oh, the legacy is the message that has gone out. It is very simply this, that however powerful you are, however mighty you may be, the law is above you. And that is the message that went out, and I hope will remain out there, and will remain to be heard by all future tyrants and dictators. It is only if they're answerable and brought to account, and are capable of being brought to account, will mankind possibly have an easier time with the sort of monsters whom we've seen in history. I mean, I know David touched upon the difficulties he had with the ambivalence of the United States administration about getting Charles Taylor. I had endless difficulties in the State Department, because when I had to finally say to the Americans, say to the Bush administration, now look, I need your support. I've got him in Freetown, and I need your support for the resolution to get him to The Hague. I had great difficulties. There were sections of the administration that didn't want me to get him anywhere. There were sections of the administration that didn't want him brought to trial. It was apparent to me that at some time or another he had been run at some stage by
And that's true. That's a true
one of
fact.
the agencies. And therefore, there were people in Washington who didn't like the prospect of this man ending up in a witness box where he might say all sorts of things. He might get back to him times, he might embarrass the US administration, and so on and so forth. So there was a certain amount of tension. And I had to battle with all that. And it wasn't easy. But finally, I must say that when the administration agreed to give me their help, I got it totally and without stinting, and I had full and complete cooperation. And had it not been for the support of that administration, the whole business of getting Charles Taylor to trial in The Hague would have been extremely difficult.
I think also another legacy, a very important legacy of the special court, beyond the Charles Taylor trial, is that even if your ultimate goal may be seen as a very laudable one, you may not, with impunity, commit crimes against humanity, war crimes, or other serious crimes to achieve that goal. And in Sierra Leone, very laudably, for the government of Sierra Leone, they cooperated with us 100% to arrest the leaders of the group that fought to reinstate the democratically elected government of Sierra Leone, the Civil Defense Force, CDF. And yet, while they were trying to achieve that goal, which many saw as very laudable, they committed these types of crimes. So that it's not just the very evil and malicious dictators of the world who are held accountable when you make these kinds of criminal acts, but anyone, even if you are pursuing what many may see as a very positive goal, you simply may not commit those crimes with impunity. And I think that's a very important lesson, and it's a very, very significant achievement for the government of Sierra Leone, who were brought back into power by this group, that they supported us in our efforts to arrest them and supported us during the trial of these leaders. So I think that's a very, very important legacy for this court.
I agree with what Brenda says, because I think I expressed it once by saying you can fight on the side of the angels and still commit war crimes. So it doesn't really matter who you're fighting for.
Yeah, defending your homeland is not a defense against war crimes and crimes against humanity.
What I like to say, the greatest legacy, and it's for us today, as we see, other leaders committing horrendous crimes, and that is that you may think that for now there won't be an end, that these people won't be brought to justice, and indeed for people that were experiencing the crimes in Liberia and Sierra Leone between 1997 and 2003, they couldn't envision a day that Charles Taylor would be brought to justice. And at least the initial solution of the sort of safe and comfortable exile that he was able to go into in Calabar had been the pattern for the past, for the Idi Amins and for the Mengistos and others that had committed crimes and had been allowed to escape and with their loot, heads you win, tails you don't lose. But basically with Taylor, we saw that the world has changed, that you can't do that, that there will be justice, no matter what the level of the individual. And so I think the lesson to everyone in the world, because in the case of Sierra Leone, there was no Chapter 7 powers that said that Nigeria had to surrender him. but there was the moral force of what the court had done with the indictment, with the evidence, and the same to be done by other courts. Other leaders will face the same kind of justice that Charles Taylor received with that verdict in April, and by the end of next year with a decision on appeal.
And to fill it all in, he received a 50-year sentence. And as for me, I would like to say and congratulate you, and to say on behalf of the Robert Jackson Center, everybody here, this has been an incredible opportunity to sit and talk to 4 individuals who, over a span of virtually 10 years, brought together an incredible sense of justice and certainly a precedent upon which many of the international humanitarian law community can seek a sense of pride. So thank you. This has been magical.
Okay, let me